A lot of developments with the Trump trials as well as Biden Incorporated legally this week. And so we wanted to get some expert reviews of the arguments that were made before the D.C. Appellate Court on immunity, the Supreme Court's decision to take up oral arguments in the Colorado Supreme Court ballot access question on February 8th, the potential conflict of interest that Fani Willis inflicted upon her constituents in Fulton County, Atlanta, and the country by extension. Lots to talk about, so we're pleased to be joined by Jed Rubenfeld. He's a professor of law at Yale Law School. Hey, that's Hunter Biden's alma mater.
Oh, that's nice.
Thanks a lot.
Yeah, did you ever have him in class?
Wait, let me finish.
Sorry,
but
okay.
But it's also Clarence Thomas's, so it just shows you some people pay more attention in class than others. So it's not necessarily impugning Yale. Jed Rubenfeld is also an expert on constitutional law and the First Amendment, author of The Interpretation of Murder. Professor Rubenfeld, thanks for joining us. Appreciate it.
Thanks for having me. Glad to be here.
Did you ever have Hunter in class?
No, I did not.
He was too busy studying tax law? Yeah. All right. You wrote an interesting piece in the Wall Street Journal, about the Colorado ballot access case, and you did some shepherdizing on the topic and came up with an 1869 case that you think is instructive for how the Supreme Court should handle Trump's appeal. Why don't you explain?
Yeah, okay, I'll be glad to. But, it helps to take a step back here. I mean, we don't do this in America. We have never, in the entire history of this country, tried to remove, a leading candidate from the ballot, lock him up. That's third world stuff. That's banana republic stuff. And we have never done it. We haven't used the legal system to try to block folks from voting for the person of their choice. That's a hugely dangerous precedent. It's risky for democracy. And, the danger is that, it's always human beings. Judges are human beings. Prosecutors are human beings. You're going to have folks with political biases who are going to be making the decisions. And it is not a good look when 4 judges in Colorado, who are appointed by a Democratic governor, vote to remove Trump from the ballot. That looks bad. People are not going to believe that was based on law. They're going to think it's based on politics. And the point I made in the Wall Street Journal piece is, it kind of was based not on law but on politics, because we don't have any law here. That's the problem. This provision from the Constitution, the 14th Amendment, has been on the books since 1866, and there's basically no law that's ever been decided under it. So judges are making it up on the fly. But way back a long time ago, 1868, 1869, the Chief Justice of the Supreme Court of the United States wrote an opinion called Griffin, and he said, look, you can't enforce this disqualification provision of the 14th Amendment unless you have some procedures that are laid out by Congress in advance. You got to have a statute. Once Congress has passed a statute, said the Supreme Court Chief Justice Chase in 1869, once they've passed a statute, okay, then fine, you can bring these cases, follow the procedures laid out. Otherwise, judges and courts are going to be making this stuff up on the fly, and we're not going to allow that. So he said that back in 1869, and honestly, I think that's the right way for the current Supreme Court to go, to follow his lead and say, look, once we have some procedures laid out in advance, so everybody's, it's all in a level playing field, and nobody is treated differently from anybody else, then you can, that's how you can and should enforce the provision of the 14th Amendment if you, do so at all. I'll just note that, 14th Amendment disqualification provision, that's for insurrection. And one thing that Donald Trump has not been charged with anywhere in the country is insurrection. I mean, the special prosecutor has not charged him with that offense. And yet you got these, state court judges and state secretaries of state who are making up their own minds about that. So, it's a bad look. It's a bad situation.
Well, speaking of insurrection, what about 2020 Black Lives Matter riots where, different government officials from Presley to Kamala Harris were pretty much suggesting that they're not going to stop and that people should join the fight?
Well, exactly. And that's a point I made in that Wall Street Journal piece. What is an insurrection? again, we have no law on this, and that's part of that's part of the problem with applying new rules to Donald Trump. I mean, whatever rules or definition courts come up with, have they applied them in the past? Have they applied them fairly? Are they being applied across the board, or is it a giant double standard? And yeah, I raised that question. I mean, if you define insurrection very broadly, I don't know why the BLM riots of 2020 are not an insurrection. And yeah, you had politicians who were encouraging it, arguably. And so, that's why whatever rules you come up with, that's why there has to be a procedure in advance. It can't look like, hey, all of a sudden we're making up new rules and applying them to Donald Trump, and we never applied them in the past, and we're never going to, but for him we're going to apply them. Because, we don't know what an insurrection is, but there's a perfectly good case that the 2020 riots were an insurrection, and there's plenty of people who think that January 6th was not.
Well, the other thing, too, it seems to me a bit ironic. It seems at one time they're interpreting the 14th Amendment and the Colorado State Supreme Court, I'm saying, essentially saying, this is to govern under the proper understanding of the 14th Amendment. And at the same time, it seems to me they're violating Trump's due process rights by making a conclusion that hasn't come through due process in terms of adjudicating the charges against him. So they're end running his due process to uphold due process.
That's a very good point. Well, so that's one of the issues. When I say there need to be rules laid out in advance, there's got to be decisions made about what kind of process is due when you're trying to enforce this disqualification provision under the 14th Amendment, which we have, almost no law on. So there is a statute. Congress has passed a statute saying that federal prosecutors can bring an insurrection charge against somebody, and if they prove it and convict the guy beyond a reasonable doubt, then that person is disqualified from federal office. It basically tracks the language of the 14th Amendment. Now, that statute suggests that the kind of due process that's required here is a criminal trial. And, okay, if you can prove to 12 jurors that there's been an insurrection and that this person engaged in it beyond a reasonable doubt, then you've got the due process that criminal law requires. Now, I'll just add that the Constitution does not itself say that. So 14th Amendment Section 3 does not say there must be a criminal trial. But the one federal statute we have on the books now does call for a criminal trial. And by the way, Congress passed a statute 150 years ago saying laying out a procedure which would not have required a criminal trial. But they got rid of it. They repealed that. So for a while, we had that provision out there, and we don't have it anymore. Now the only statute we do have requires a criminal trial. And if you go under that, you have to prove it beyond a reasonable doubt. And there has been nothing like that kind of due process so far in any of these cases. The Colorado case, the Maine Secretary of State's decision, and so forth.
The Fani Willis matter in Fulton County, Georgia, and the appointment of her paramour to be special prosecutor, where she's approving his payments to him and his bills and so forth. A number of legal scholars have said, well, if this is true, as has been represented in court filings, then it's definitely an ethical breach. Is that an ethical breach that would preclude, in your mind, the ability of that case to go forward for her to prosecute Trump and his cohorts under the racketeering charges that she's filed?
I'm going to be honest with you here. I don't like to opine on something where I don't know the facts. Well, none of us knows the facts. And everybody, I know a lot of law professors, they want to jump in and say, oh, this is an outrage. It's an ethical violation. Sure, sounds like one based on the headlines, but I don't want to get in the business of convicting somebody before we know the basic facts, if there's any evidence. So, to answer your legal question, it's unlikely that this would derail the entire prosecution. They might, at worst, they might have to appoint somebody else to oversee it, something like that. But, even that we don't know. Even that will depend on facts. So I just feel it's too early to be trying to jump in there and say what's going to happen or what should happen.
Fair enough. He is Professor Jed Rubenfeld, professor of law at Yale Law School, expert on con law and the First Amendment, author of The Interpretation of Murder. Professor Rubenfeld, thanks so much for joining us. Appreciate it.
Oh, thanks for having me. It was great.
Thank you. And he joined us on our turnkey.pro answer line.
It's like a hot, steaming cup of information to start your day. It's Chicago's Morning Answer on AM 560. The Answer. You're smart, you're busy, and don't have time to waste on the mainstream media cycle. Salem News Channel breaks that cycle. Topics that matter from hosts worth watching. Dinesh D'Souza, Andrew Wilkow, Brandon Tatum, and more. Open debate and free speech you won't find anywhere else. Salem News Channel. Not like the other guys. Watch anytime on any screen. Free 24/7. Find everything you need to know at snc.tv. That's snc.tv.
There's no better time than the new year to help protect your identity and finances. LifeLock detects potential threats to your identity that you may miss on your own. If you do become a victim, a U.S.-based LifeLock restoration specialist will work to fix it. LifeLock is the New Year's resolution that's easy to keep. Save 25% off your first year